by stating, quote, Mr. President. Quote, why do we ignore and do not implement Security Council resolutions? Why? We ask the whole world. Why the Palestinian people plight continues? Why the international community incapable of resolving this cause? Why does the victims continue to be portrayed Why does the victim continue to be portrayed as a killer according to Israel's norms? Why does Israel always escape punishment? Why have all these souls been lost amid absence of world conscience? Unquote. Sorry, Mr. President.
Sorry.
Mr. President, distinguished members of the court, it is in this context that Kuwait appears for the first time before the court, following the adoption by the UN General Assembly of resolutions 77247, requesting the court to deliver an advisory opinion on two legal questions. The first question asks the court to evaluate the illegality of the occupying power's specific policies and actions within its occupation of the Palestinian territories, while seeking the court's determination of the corresponding legal ramification. The second question addresses the core issue. Has the occupation become illegal? Kuwait will demonstrate the illegality of this occupation, underscoring the necessity of its cessation. Mr. President, honorable members of the court, my distinguished colleagues will now address these issues in greater depth. Second, first, His Excellency Ambassador Tariq Al-Bannai, permanent representative of Kuwait to the UN, will address why the court does have jurisdiction to deliver the advisory opinion requested by the UN General Assembly. He will also highlight certain legal practices and policies of the occupying power. Second, Her Excellency Tahani al-Nasser, Assistant Foreign Minister for Legal Affairs of Kuwait, will start by enumerating the grounds proving the illegality of the occupation of the Palestinian territories, hereafter referred to as the OPT. She will then focus on the legal consequences arising from the breaches of those fundamental rules. And finally, she will provide the court with a certain concluding remarks. Thank you, Mr. President, honorable members of the court, for the privilege of appearing before you. I now kindly ask you, Mr. President, to invite Ambassador Al-Bannai to address the court.
I thank His Excellency, Mr. Al-Dhafiri. I now give the floor to His Excellency, Mr. Tariq Al-Bannai. You have the floor, Excellency.
Mr. President, honorable members of the court, it is a tremendous honor and privilege to appear before you on behalf of the State of Kuwait. 20 years have passed since the seminal Wall Advisory Opinion. Today, in these current proceedings, the question of the illegality of the occupation of the Palestinian territory is directly before the court. With your permission, I turn now to my first topic, focusing on whether the court has jurisdiction to render the advisory opinion requested. In Kuwait's view, the answer is a categorical yes. Indeed, the majority of submissions in these proceedings argue in favor of the court's jurisdiction. Article 65 of the Statute of the Court provides that the Court may render an advisory opinion, and I quote, on any legal question at the request of any organ or institution authorized by the Charter of the United Nations or in accordance with its provisions to request such an opinion, unquote. In turn, Article 96 of the UN Charter, quote, the General Assembly or the Security Council may request the International Court of Justice for an advisory opinion on any legal question, unquote. In practice, it is primarily the General Assembly that has most frequently utilized this procedure to date. After all, when the General Assembly decides to request the Court to deliver an advisory opinion, this means that the request reflects an important concern of the international community, seeking a legal answer. The Court itself observed that the General Assembly, within the scope of its peacekeeping responsibilities, has a broader perspective than that of the Security Council, as it also considers humanitarian, social, and economic aspects. An attentive look at the Court's jurisprudence points to the fact that, quote, only compelling reasons may lead the Court to refuse its opinion in response to a request falling within its jurisdiction, unquote. Although the Court has the discretionary power to refuse to respond to a request for an advisory opinion for reasons of judicial propriety, it has not availed itself of this option thus far. In the present case, it is incontestable that the questions included in the relevant General Assembly resolution are clearly specific questions of legal character. Any attempt to qualify them as non-specific or non-legal should fail. It is worth noting that the Court, in the Wall advisory opinion, rejected similar attempts. In essence, in the Wall advisory opinion, the central issue revolved around the construction of the wall and its impact on the right to self-determination of the Palestinian people. 20 years later, the context has broadened substantially. The Court is now tasked with determining the legal status of the ongoing occupation of the occupied Palestinian territory since 1967, given its persistence for over 57 years. Prior to addressing the next topic, I feel compelled to briefly refer to an argument certain states have made, fallaciously alleging that the issuance of an advisory opinion might undermine ongoing negotiations and peace processes. This argument, Mr. President, honorable members of the Court, is groundless and without merit. Kuwait has always underscored the importance of resuming peace negotiations with a view of reaching a just and comprehensive peace, based on the terms of reference of the peace process, the resolutions of the Security Council, and the Arab Peace Initiative. However, the relevant UN resolutions and the Wall advisory opinion make clear that any negotiations that take place must have as their objective the achievement of a just and lasting peace in accordance with international law. The Court has an important role to play in this regard by stating what the applicable rules of international law are, including the rights and obligations of the relevant parties, all states and the United Nations. This is exactly the purpose of the UN General Assembly resolution requesting the Court to deliver an advisory opinion. By doing so, the Court may in fact help revive negotiations and inspire a return to a peace process premised on international law. After all, the Court's advisory opinions shed light on complicated legal issues, appeasing tensions, uncertainties, and potential disputes. Mr. President, honorable members of the Court, I will now address our second topic, providing you with examples of the occupying power's unlawful and egregious policies and practices in the OPT. In the interest of time, I will limit my presentation to three policies: which demonstrate the true nature of the illegal occupation. The first is forced displacement. The second relates to the illegal settlements on and the annexation of the Palestinian territory. And the third is discrimination at a scale and nature that amounts to apartheid. The remaining issues were discussed thoroughly in the written submission of Kuwait. In the 1948 Nakba, 750,000 Palestinians were forcibly displaced. And since then, millions more. The situation has deteriorated exponentially since the illegal occupation started in 1967. The occupying power has engaged in a forced displacement campaign against the Palestinians by demolishing their homes and confiscating their lands. Forced displacement violates international law. The occupying power is under the obligation to ensure that its operations in the OPT comply with the Fourth Geneva Convention of 1949 relative to the protection of civilians, persons in time of war, to which it is a party. Article 49 of this convention clearly prohibits, quote, forcible transfers, individual or mass, regardless of their motive, unquote, which includes forced displacements, as well as expulsions from the OPT. Furthermore, Article 53 of the same instrument prohibits the destruction of property. Finally, under Article 147, illegal transfers, destruction, and appropriation of property carried out on a large scale is prohibited. As Kuwait explained in its written submission, the occupying power has also committed other grave violations of international law, including the policy of settling parts of its population in the OPT. This unlawful policy has and continues to be deplorably promoted by the successive governments of the occupying power. Since 1967, the occupying power has embarked on an intensive campaign of colonization. Some settlements consisted of just a few prefabricated houses, while others expanded to become fully fledged small towns. In early 2023, there were around 730,000 Israeli settlers and over 280 Israeli settlements in the occupied West Bank, including 230,000 settlers in East Jerusalem. These settlements are sustained by a network of military checkpoints and restricted zones, as well as Jewish-only roads and highways, all of which limit gravely the lives and livelihoods of Palestinians and violate their fundamental human rights. Both the construction of settlements and the transfer of settlers to the West Bank and Gaza are grave violations of international law. In particular, Article 49 of the Fourth Geneva Convention, which states that, I quote, the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies, unquote. It is also noteworthy, Mr. President, that settlers in the OPT are not governed by the same laws that apply to the indigenous inhabitants of the territory. Jewish settlers are provided with special rights, facilities, and subsidies that are denied to the indigenous Palestinian population. The occupying power's policy not only supports the existing settlers, but also incentivizes new settlers. The discriminatory policies and practice also violate the sovereignty of Palestinians over their natural resources, allowing the settlers and foreign companies to exploit the water and agricultural products of the occupied land without any benefit to the occupied population. It is widely recognized that the occupying power has codified its discriminatory policies and practices against Palestinians in its legislation. Specifically, it grants rights to Israeli Jews and systematically discriminates against Palestinians. For instance, The Land Acquisition Law of 1953 facilitates the alienation of confiscated Palestinian land for the benefit of various institutions of the occupying power. Quasi-public organizations, such as the Jewish Agency, engage in material discrimination, in particular through the allocation of confiscated Palestinian land to Israeli Jews. Mr. President, honorable members of the court, thank you for your kind attention, and may I kindly ask that you invite Her Excellency Tahani al-Nasser to the podium.
I thank His Excellency Mr. Al-Banai, and now I'll give the floor to Her Excellency Mrs. Tahani al-Nasser. You have the floor, Excellency.
Thank you. Mr. President, distinguished members of the court, it's a great honor and a privilege to appear before you on behalf of Kuwait. In the written submissions, the great majority of states participating in these proceedings, along with the three intergovernmental organizations, concluded that the occupation of the OPT is illegal. Kuwait firmly agrees with this view in its written submission. Kuwait identified several reasons proving the illegality of this occupation. I will provide a brief overview of these reasons for the court. The occupation violates a series of jus cogens norms. First, the obligation to respect the right to self-determination of the Palestinian people. The right of people to self-determination is a right clearly recognized in international law as evidenced by several instruments and as submitted by 35 states and international organizations participating in these proceedings. This is articulated in Article 1.2 of the UN Charter, which define the purposes of the United Nations, including, I quote, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, and to take other appropriate measures to strengthen a universal peace. Unquote. The same obligations are expressed in Article 1 of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Second, Kuwait joined the participants in these proceedings is illegal because it violates the jus cogens prohibition on the use of force. Third, the occupying power, by confiscating and annexing parts of the OPT, violates the prohibition on the acquisition of territory by force. This was underscored by 38 participants in the written proceedings. This fundamental norm was incorporated into Security Council Resolution 242 of 1967 and reaffirmed in Security Council Resolution 338 of 1973. Accordingly, the occupying power does not have the right to claim sovereignty over the OPT occupied since 1967. Fourth, the occupation is illegal because it obviously violates the law of military occupation. For instance, the occupation of the OPT is not of minimal duration. Facts clearly demonstrate that it is intended to be prolonged and ultimately permanent. A permanent occupation constitutes a serious violation of international law based on the verifiable evidence available to us. It's indisputable that this is precisely what is happening in the OPT. This prolonged occupation and identified violation of the Palestinians' right to self-determination renders the occupation illegal. Moreover, the conduct of the occupying power in the OPT violates the rules of international humanitarian law. In the Wall Advisory opinion, the court stated that, quote, the Fourth Geneva Convention is applicable in the occupied Palestinian territories, unquote. The court also determined that the Hague regulations are reflective of customary international law and thus applicable to the conduct of the occupying power in the OPT. Far from complying with the law of occupation, the actions of the occupying power disregard international law. These actions include, inter alia, the establishment of settlements in the OPT, confiscation of Palestinian public and private property, and its failure to protect Palestinians from violence caused by state actors and private parties, including inter alia armed illegal settlers. Finally, the occupation violates the jus cogens prohibition of apartheid. 21 participants in these proceedings supported this in their written submissions, while 14 maintained that the situation of apartheid qualifies the occupation as illegal under international law. The prohibition of apartheid is evidenced in various sources of international law. The occupying power is bound by the 1965 Convention on the Elimination of All Forms of Racial Discrimination, to which it is a party. Furthermore, it shall abide by the prohibition of apartheid as enshrined in 1973 International Convention on the Suppression and the Punishment of the Crime of Apartheid, which codifies customary international law. Several voices and independence experts have warned that the occupation of the OPT amounts to a regime of apartheid. For instance, in March 2022, the Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967, in his report reached a similar conclusion. Kuwait, respectively, suggested that the above violations cannot be reconciliated with the fundamental rules of international law. Hence, the occupation must be declared illegal in accordance with international law and the relevant UN Security Council resolution. It must stop. This will guarantee the right of the Palestinian people to be a valuable state and along 1967 borders with East Jerusalem at its capital. Mr. President, members of the Court, the legal analysis of the question involved in these advisory proceedings demonstrate that the occupation of the OPT is illegal, in contravention of the fundamental rules of international law. It is written submission, Kuwait did address the legal consequences arising from the occupying powers, numerous and long-standing violations of these rules. Please allow me to provide with a view d'ensemble. As indicated, the action of the occupying power and the occupation as a whole are plenarily incompatible with the rights of the Palestinian people and obligations of the occupying power under international law. Its breaches of these rights and obligations engage the occupying power's international responsibility. The occupying power must therefore take several measures. First, it must provide Palestinians with relief in accordance with the principles of customary international law on the responsibility of states for internationally wrongful acts. This must be achieved through the immediate cessation of its illegal occupation. Second, the occupying power must give assurance and guarantees of non-repetition of its international law violations. The occupying power shall commit itself to not repeating the same breaches in the future. Finally, the occupying power is under the obligation to make full reparation for the injury caused by its occupation and discriminatory policies and practices. As for all other states, they are all obliged to refrain from acknowledging the legality of the situation created by the illegal occupation and associated illegal policies and practices. They shall also abstain from offering support or assistance to sustain the circumstances stemming from the unlawful occupation and associated actions. Third, the state shall also contribute to safeguarding the Palestinian population against war crimes, genocide, and the crimes against humanity, and ensure that those responsible for crimes committed within the framework of illegal occupation are held accountable. In turn, the UN shall refrain from acknowledging the legality of the situation resulting from the illegal occupation and associated actions. The UN shall also refrain from offering support or assistance to prolong the situation and should instead cooperate to bring an end to the illegal occupation. Mr. President, honourable members of the Court's advisory opinion is now more than ever necessary to put an end to the illegal occupation of the OPT. Kuwait has sought to concisely summarize the grounds for finding that the occupation is illegal as a whole, and submits that each ground of illegality shall form part of the Court's dispositif. We are confident that the Court will assess Kuwait's written submission and oral statement as expression of its faith in justice, its support for the rule of law, and its desire for peace for all states in the region. Mr. President, honorable members of the court, this ends Kuwait's oral statement. Kindly allow me, on behalf of Kuwait's delegation, to thank the court for its kind attention, as well as the registry staff and the interpreter for all their support. Thank you very much.
I thank the delegation of Kuwait for its presentation. J'invite maintenant la délégation de l'État participant suivant, le Liban, à prendre la parole devant la Cour. Appelle son Excellence, M. Abdesattar Issa Alabar. Excellence, vous avez la parole.
Monsieur le Président, Mesdames et Messieurs membres de la Cour, c'est un immense honneur de m'adresser à vous afin d'exposer les observations orales du Liban au sujet des conséquences juridiques découlant des politiques et pratiques d'Israël dans le territoire palestinien occupé, y compris Jérusalem-Est. C'est un sujet de la plus grande importance pour mon pays, ainsi que l'ensemble de la communauté internationale. Le nombre record des demandes d'intervention orale devant votre auguste Cour en est la preuve la plus probante. Ayant exposé par écrit les vues du Liban sur les divers aspects juridiques des questions posées, et par respect des règles pratiquées lors des plaidoiries qui invitent à la brièveté, je me contenterai d'élaborer 3 points qui ont pris de l'importance vu la gravité des événements qui se déroulent depuis le mois d'octobre dans le territoire palestinien. Ces 3 points sont l'opportunité de l'intervention de la Cour, le caractère impératif des normes de droit international violées par Israël, en particulier l'interdiction du recours à la force et le droit à l'autodétermination, et enfin les conséquences juridiques qui découlent de ces violations. L'opportunité de l'intervention de la Cour. Monsieur le Président, Mesdames et Messieurs, on est à quelques mois du 20e anniversaire de la vie historique de votre illustre Cour, que votre illustre Cour a rendu au sujet de l'édification d'un mur dans le territoire palestinien occupé. Or, certains États avaient évoqué au cours de la procédure de cet avis, comme ils le font actuellement, une observation qui incite la Cour à ne pas rendre son avis, car son intervention bloquerait des négociations en cours entre les parties, qu'elle risquerait de rendre beaucoup plus difficile ou même impossible l'accommodement politique nécessaire, qu'il y a une feuille de route à suivre. Nous voici 20 ans après, toujours sans solution négociée, sans négociation tout court, par contre avec des milliers de morts et la destruction massive d'infrastructures civiles. Demander à la Cour de ne pas intervenir, de ne pas rendre son avis consultatif au nom d'un processus de négociation bilatérale à protéger, d'une solution politique à préserver, est un argument pervers qui crée un antagonisme entre le politique et le juridique, alors qu'ils sont dans toute société, y compris la société internationale, 2 éléments complémentaires en relation dialectique. Le droit cadre le politique, empêche sa dérive, que ce soit au niveau public ou privé. Le droit garantit un minimum de justice dans les relations. Madame Chemillier-Gendreau avait en 2004 clairement décrit ce fait en plaidant devant cette Cour, je cite, « Le politique, c'est la confrontation des subjectivités des différents acteurs sociaux dans un processus direct qui révèle un rapport de force que rien ne vient atténuer. Le juridique est le transfert de ce heurt des subjectivités en référence à un standard préalablement établi, la norme de droit, et devant une instance tierce offrant des garanties d'objectivité. La confrontation à la norme de référence effectuée par un tiers impartial introduit cet espace d'objectivité qui permet de corriger la situation de fait. » Fin de citation. Cette objectivité, Monsieur le Président, Mesdames et Messieurs membres de la Cour, c'est cette objectivité, Monsieur le Président, Mesdames et Messieurs membres de la Cour, qu'on est venu chercher encore une fois auprès de vous. Permettez-moi de passer au 2e point. Le caractère impératif des normes violées par Israël. Comme on l'a déjà mentionné dans nos observations écrites, la notion de norme impérative jusqu'au gens s'est précisée grâce au travail laborieux de la Commission de droit international depuis 2016. En parlant du travail de la Commission, je voudrais répondre à l'observation émise par certains États qui veut que les projets d'articles ou conclusions proposés par cette Commission ne puissent être considérés comme des concepts établis. Cette observation, mesdames et messieurs, minimise le rôle que joue cet organe au nom de l'Assemblée générale des Nations unies dans le développement et la codification du droit international. J'invite la Cour à examiner mon observation sur l'observation à la lumière de l'article 38 de son statut. Revenons aux normes impératives. La Commission avait établi une liste non exhaustive de 8 normes impératives. Quand le Liban avait présenté son exposé écrit, il considérait qu'Israël violait au moins 4 des 8 normes citées. Depuis, et vu les horreurs que subissent les Palestiniens à Gaza, Israël est accusé, triste ironie de l'histoire, de violer une cinquième norme des 8, et pas la moindre, l'interdiction du génocide. Comme je l'ai annoncé au début, je me limiterai à 2 des normes impératives mentionnées dans notre exposé écrit. L'interdiction du recours à la force et le droit à l'autodétermination. La justification de ce choix me paraît évidente. La violation de ces 2 normes par Israël est la cause directe ou indirecte de ces violations du restant des normes mentionnées dans notre exposé écrit. Que ce soit les normes du droit international humanitaire, les droits humains ou l'interdiction de l'apartheid. Qu'Israël cesse son occupation du territoire palestinien, y compris Jérusalem-Est, qu'il accepte le droit du peuple palestinien à l'autodétermination, et toutes ces autres violations disparaîtront. Je voudrais ajouter à ce sujet que nombreux sont les États qui ont évoqué, je dirais même insisté, dans leurs observations écrites et orales, sur le caractère prolongé de l'occupation israélienne afin de la qualifier comme une annexion illégale des territoires palestiniens. C'est une argumentation valable et correcte, Monsieur le Président, mais elle doit être prise comme faisant partie des circonstances aggravantes du crime, pas le crime même, qui est le crime de l'agression. En effet, depuis 1945, l'usage de la force est strictement réglementé en droit international. Et Israël commet depuis 1967 un crime d'agression, où il occupe illégalement des territoires avant de les annexer. En d'autres termes, l'occupation des territoires qui résulte d'un usage illégal de la force est illégale, quelle que soit sa durée. Nous voilà face à la première norme impérative violée par Israël, l'interdiction du recours à la force. L'interdiction du recours à la force est une des normes impératives bien établies et elle est clairement énoncée par l'article 2, paragraphe 4 de la Charte des Nations Unies qui stipule que les membres de l'organisation s'abstiennent dans leurs relations internationales de recourir à la menace ou à l'emploi de la force, soit contre l'intégrité territoriale ou l'indépendance politique de tout État, soit de toute autre manière incompatible avec les buts des Nations Unies. L'Assemblée générale avait adopté en 1974, par sa résolution 3314, une définition de l'agression qui énumère d'une façon non exhaustive plusieurs modalités de recours illicite à la force. Selon l'annexe de la résolution 3314, est une agression toute occupation militaire, même temporaire, toute annexion par l'emploi de la force du territoire ou d'une partie du territoire d'un autre État, le blocus des ports ou des côtes d'un État. Ainsi, l'occupation des territoires palestiniens par Israël et son blocus de la bande de Gaza constituent des actes d'agression. Ce fait a été constaté à maintes reprises par le Conseil de sécurité des Nations Unies, qui ne cesse depuis 1967 de demander à Israël de mettre fin à son occupation. L'Assemblée générale, de son côté, est plus explicite dans sa condamnation de l'occupation israélienne des territoires palestiniens. Elle a déclaré récemment, par exemple, l'inadmissibilité de l'acquisition de territoires par la force et donc le caractère illégal de l'annexion de toute partie du territoire palestinien occupé, y compris Jérusalem-Est, qui constitue une violation du droit international. La Cour a toujours affirmé de son côté l'illicéité du recours à la force et de l'acquisition des territoires par la force, y compris dans son avis consultatif sur l'édification du mur, où elle a également rappelé le caractère coutumier de cette interdiction. Certains pourraient émettre des doutes sur l'application de la norme interdisant le recours à la force sur la base que c'est une norme interétatique, insinuant que les territoires palestiniens occupés ne font pas partie d'un État. À cela, on peut répondre, mesdames et messieurs, que le Liban, ainsi que plus de 140 États membres des Nations Unies, reconnaissent l'État de Palestine et Jérusalem-Est comme sa capitale. L'État de Palestine est membre de plusieurs organisations internationales comme l'UNESCO, l'OIAC, l'OIC, la Ligue des États arabes et la CPA, et la Palestine est membre observateur des Nations Unies, dont le secrétaire général, M. Guterres, déclarait il y a moins d'un mois que le droit du peuple palestinien d'édifier son propre État pleinement indépendant doit être reconnu par tous. Et tout refus d'accepter la solution des deux États par quelque partie que ce soit doit être fermement rejeté. Ce serait d'ailleurs une occasion opportune pour la Cour de donner son avis sur ce point. Dans tous les cas, Monsieur le Président, Mesdames et Messieurs membres de la Cour, l'interdiction du recours à la force ne se limite pas en droit international aux relations entre États, mais à toute utilisation contraire aux principes et buts de la Charte des Nations Unies. Or, Israël continue son occupation et ses politiques qui visent clairement à annexer les territoires palestiniens. Il encourage la colonisation, la confiscation des terres, la destruction des bâtiments publics et privés, afin de rendre sa présence un fait accompli et irréversible. Ceci malgré toutes les résolutions successives du Conseil de sécurité, à commencer par la résolution 242. Vu ce qui précède, le Liban prie la Cour de considérer une nouvelle fois qu'Israël viole le principe fondamental de l'illicéité du recours à la force et son corollaire de l'illégalité d'annexion des territoires par la force. Le droit à l'autodétermination. Le Liban considère que le droit du peuple palestinien à l'autodétermination est irréfutable et on ne peut trouver de mots plus éloquents que ceux employés par la Cour pour affirmer cette réalité. Je cite, « La Cour observe que l'existence d'un peuple palestinien ne saurait plus faire de débat et que parmi les droits de ce peuple figure le droit à l'autodétermination. » Fin de citation. Le droit à l'autodétermination est une norme impérative de droit international consacrée dans divers textes, y compris la Charte des Nations Unies, qui établit ce droit comme un des fondements des relations amicales entre les nations. Or, ce socle du droit international moderne comporte plusieurs facettes, toutes violées par Israël. La Cour s'est penchée dans son avis consultatif sur les effets juridiques de la séparation de l'archipel des Chagos de Maurice en 1965, sur la nature et surtout le contenu du droit à l'autodétermination. Elle a rappelé que le droit à l'autodétermination est une règle coutumière et que la résolution de l'Assemblée générale 1514 avait un caractère déclaratoire. Cette résolution, adoptée en 1960, fut l'un des premiers textes à préciser le contenu et la portée du droit à l'autodétermination. On y affirme que l'autodétermination des peuples implique qu'ils puissent déterminer librement leur statut politique et poursuivre leur développement économique et social. La résolution mentionne aussi qu'il faut mettre fin à toute action armée et à toute mesure de répression, de quelque sorte qu'elle soit, dirigée contre les peuples dépendants, pour permettre à ces peuples d'exercer pacifiquement et librement leur droit à l'indépendance complète et l'intégrité de leur territoire national sera respectée. Elle indique clairement aussi que toute tentative visant à détruire pour permettre à ces peuples d'exercer pacifiquement et librement leur droit à l'indépendance complète et l'intégrité de leur territoire national sera respectée. Elle indique clairement aussi que toute tentative visant à détruire partiellement ou totalement l'unité nationale et l'intégrité territoriale est incompatible avec les buts et principes de la Charte des Nations Unies. Par ailleurs, le premier article commun au pacte de droits civils et politiques et le pacte des droits économiques et sociaux et culturels affirme aussi le droit des peuples à l'autodétermination et reprend les principaux éléments qui constituent ce droit. Comme je l'ai évoqué précédemment, le Liban considère qu'Israël viole tous les éléments constitutifs du droit du peuple palestinien à l'autodétermination, qui sont 1. L'indépendance politique et économique, 2. La souveraineté permanente sur les richesses et ressources naturelles, et 3. L'intégrité territoriale. La tergiversation d'Israël depuis des décennies, malgré tous les accords qu'il a conclus et les appels de la communauté internationale à reconnaître l'indépendance de l'État palestinien, est une violation continue du premier élément du droit à l'autodétermination. La politique israélienne de confiscation de territoires agricoles, d'exploitation des ressources hydrauliques et minières des territoires palestiniens occupés est une violation continue du deuxième élément constitutif du droit à l'autodétermination, qui est la souveraineté permanente des peuples sur leurs ressources naturelles. Le troisième élément constitutif du droit à l'autodétermination, l'intégrité territoriale, a été rappelé par la Cour quand elle a déclaré que le droit à l'autodétermination du peuple concerné est défini par référence à l'ensemble des territoires non autonomes et ainsi que le souligne le paragraphe 6 de la résolution 1514. La Cour considère que les peuples des territoires non autonomes sont habilités à exercer leur droit à l'autodétermination sur l'ensemble de leur territoire, dont l'intégrité doit être respectée par la puissance administrante. Or, Israël, par sa politique de colonisation et de construction d'infrastructures qui relient ces colonies, grignote et morcelle les territoires palestiniens, y compris à Jérusalem. Cette atteinte systématique et continue à l'intégrité du territoire palestinien est constatée et documentée dans plusieurs rapports d'enquête internationale. On arrive maintenant, Monsieur le Président, Mesdames et Messieurs, au troisième point, les conséquences juridiques des violations d'Israël. Les points précédents montrent qu'Israël continue de violer des normes impératives de droit international, des normes qui créent des obligations erga omnes. La Cour avait déjà constaté ce fait dans son avis consultatif en 2004, où elle a déclaré qu'au rang des obligations internationales violées par Israël figurent des obligations erga omnes. De telles obligations, par leur nature même, concernent tous les États. Et vu l'importance des droits en cause, tous les États peuvent être considérés comme ayant des intérêts à ce que ces droits soient protégés. La nature des obligations violées entraîne dans ce cas une responsabilité spécifique d'Israël, mais aussi une responsabilité des États tiers. En effet, le caractère continu et systématique des actions politiques israéliennes constitue une violation aggravée qui entraîne 3 genres d'obligations pour les États, selon l'article 41 du projet d'article sur la responsabilité de l'État recommandé par l'Assemblée générale des Nations unies en 2001. Ainsi, on abordera les conséquences juridiques vis-à-vis d'Israël, puis vis-à-vis des États tiers. Les conséquences juridiques vis-à-vis d'Israël. Comme je l'ai mentionné plus haut, Israël commet une violation grave du droit international public selon la définition de l'article 40 du projet d'article sur la responsabilité de l'État pour faits internationalement illicites. Ces violations étant systématiques et continues, Israël est tenu de cesser ces actes illicites et d'offrir des assurances de non-répétition, selon l'article 30 du projet d'article sur la responsabilité de l'État. Concrètement, Israël est tenu dans ce cas, afin de respecter le principe du non-recours à la force et son corollaire de l'inadmissibilité de l'annexion des territoires, de démanteler les colonies dans les territoires palestiniens occupés et de se retirer de ces territoires. La Cour avait déjà affirmé dans son arrêt sur les conséquences juridiques de l'édification d'un mur dans le territoire palestinien occupé qu'Israël est en conséquence tenu de restituer les terres, les vergers, les oliveraies et les autres biens immobiliers saisis à toute personne physique ou morale. Israël est tenu aussi de cesser sa violation du droit à l'autodétermination du peuple palestinien, de mettre fin à son occupation des territoires palestiniens et de reconnaître l'État de Palestine. Par ailleurs, Israël restera dans une situation illégale tant qu'il n'applique pas les résolutions du Conseil de sécurité qui traitent des différents aspects de son occupation des territoires palestiniens. En effet, mesdames et messieurs, la Cour a déjà précisé en 2004, je cite, « Lorsque le Conseil de sécurité adopte une décision au terme de l'article 25 conformément à la Charte, il incombe aux États membres de se conformer à cette décision, notamment aux États qui ont voté contre elle et aux membres des Nations unies qui ne siègent pas au Conseil. Ne pas l'admettre serait priver cet organe principal des fonctions et pouvoirs essentiels qu'il tient de la Charte. » Fin de citation. On peut dire, mesdames et messieurs, de tout ce qui précède, que l'occupation israélienne du territoire palestinien est illégale, tant dans sa conduite que dans son but. Par conséquent, Israël est dans l'obligation de mettre un terme immédiat et inconditionnel à cette situation illégale dont il est internationalement responsable et de fournir réparation. Les conséquences vis-à-vis des États tiers. Vu que les normes violées par Israël sont des normes impératives, ces violations affectent tous les États du fait de leur caractère erga omnes. Le projet d'article sur la responsabilité de l'État pour faits internationalement illicites stipule dans son article 41 que 1. Les États doivent coopérer pour mettre fin par des moyens licites à toute violation grave de l'article 40. 2. Aucun État ne doit reconnaître comme licite une situation créée par une violation grave au sens de l'article 40, ni prêter aide ou assistance au maintien de cette situation. La Cour avait déjà confirmé ces éléments qui incombent aux États en cas de violation d'obligations erga omnes quand elle déclara dans son avis sur les conséquences juridiques de l'édification d'un mur dans le territoire palestinien occupé en 2004, je cite, « Vu la nature et l'importance des droits et obligations en cause, la Cour est d'avis que tous les États sont dans l'obligation de ne pas reconnaître la situation illicite. Ils sont également dans l'obligation de ne pas prêter aide ou assistance au maintien de la situation. Il appartient par ailleurs à tous les États de veiller, dans le respect de la Charte et du droit international, à ce qu'il soit mis fin aux entraves à l'exercice par le peuple palestinien de son droit à l'autodétermination. » Fin de citation. De ce qui précède, on peut dire que les conséquences des violations israéliennes sur les États tiers sont les suivantes. Premièrement, les États doivent coopérer par tout moyen licite afin qu'Israël se retire des territoires palestiniens occupés, arrête sa politique d'expansion des colonies et démantèle les colonies existantes. Et enfin, reconnaissent le droit à l'autodétermination du peuple palestinien. Deuxièmement, les États ne doivent pas reconnaître la situation de fait accomplie qu'Israël a créée dans les territoires palestiniens occupés et surtout le changement du statut et de la situation démographique de la ville de Jérusalem. En somme, l'occupation israélienne du territoire palestinien est illégale et doit cesser immédiatement et sans condition. En conséquence, les États tiers et les organisations internationales sont tenus de soutenir, sans délai, les efforts visant à mettre un terme immédiat et inconditionnel à cette occupation et de s'abstenir de toute action ou omission qui contribue au maintien de la situation illégale. En parlant des organisations internationales, et vu que la Cour est censée répondre à des questions adressées par l'Assemblée générale des Nations unies, une responsabilité particulière incombe à cette organisation. L'Organisation des Nations unies, et en particulier l'Assemblée générale et le Conseil de sécurité, devraient prendre les mesures nécessaires pour assurer la mise en œuvre de leurs résolutions pertinentes sans aucun retard et examiner les mesures supplémentaires nécessaires pour mettre fin à tout obstacle à la réalisation par le peuple palestinien de son droit à l'autodétermination, mettre fin à l'occupation, la colonisation et l'annexion prolongée du territoire palestinien par Israël, notamment aux mesures visant à modifier la composition démographique, le caractère et le statut de la ville sainte de Jérusalem. Mesdames et Messieurs, le Liban prie la Cour de se considérer compétente pour répondre à la demande d'avis consultatif contenue dans la résolution 77/247 de l'Assemblée générale et de le faire à la lumière de ses observations écrites et orales. Mr. President, ladies and gentlemen, members of the Court, the late Pope John Paul II once said, "If you want peace, work for justice. If you want justice, defend life. If you want life, embrace the truth." As the highest judicial authority in our globalized world, Lebanon urges you to help in giving justice to the Palestinian people so we can have peace in the Middle East. Thank you.
Je remercie la délégation du Liban pour son exposé. I invite the next participating delegation, Libya, to make its oral statement before the court. I thus call upon Professor Ahmad Al-Gihani to take the floor. You have the floor, sir.
Mr. President, distinguished judges, good afternoon. It is my honor to be here before the court. It is the first time with my delegation in representing the Libyan submission to your court. First, let me say that the suffering of the Palestinian people, and in particular in Gaza Strip, nowadays are a clear evidence of consequences of the failure to address the Palestinian cause. The world is witnessing a large-scale and systematic heinous crimes being committed by the occupying power force, depriving the civilian population of food, water, and essential supplies. The aggression of the power of occupying power has not spared children, women, elderly people. There is no safe place for the people in Gaza to go to. The crimes amounted by Israel, the crime committed by Israel tantamount to the crime of genocide and other international crimes stated in the Article 5 and 6 and 7, 8 for the Rome Statute. This call on the international community as a whole and on organs of the United Nations to put an end to this tragedy and take concrete steps in order to enable the Palestinian people to realize their legitimate rights of self-determination. Therefore, we believe guidance from the court as the highest judicial organs in United Nations, and it is necessary and important. The presentation of the state of Libya before your court will address the following points. First, the jurisdiction of the court, then the legality of the occupation of the Palestinian territory, then the consequences of the Israeli illegal actions, and then the summit. We can start from the first point, that the jurisdiction of the court, as you know, Mr. President, member of the court, that the Article 96, paragraph 1 of the United Nations Charter provides that the General Assembly or the Security Council may request the International Court of Justice to give an advisory opinion on any legal question. On the other side, the Article 65, paragraph 1 of the court's statute further stipulates that the court may give an advisory opinion on any legal question at the request of whatever body may be authorized by or in accordance with the Charter of the United Nations to make such request. These two provisions are, according to our view, sufficient to establish the competence of the General Assembly to request the advisory opinion from the court and the jurisdiction of the court to give the requested opinion. We go to the second point, the applicable law. The international humanitarian law. First, the international humanitarian law. It is, as you know, settled that 1949 Geneva Convention relative to the protection of civilian persons in times of war apply to the OPT, as noted by the court in the Wall opinion. In addition of that, the 1907 Hague Regulation have become a part of customary law and therefore apply to the OPT, despite the Israeli argument that the Fourth Geneva Convention does not apply to the OPT. The court found, as a matter of treaty law, that does indeed apply, as it would to say, and occupied territory to prevent an armed conflict arising between two or more high contracting parts. In 2001, the Conference of High Contracting Parties reaffirmed the applicability of the Fourth Geneva Convention in the occupied Palestinian territory, including East Jerusalem, Quds, and called inter alia upon the occupying power to immediately refrain from committing grave breaches involving any of the acts and mentioned in the Article 147 of the Fourth Geneva Convention, such as killing, torture, deportation, depriving of the rights of fair and regular justice and trial, extensive destruction and appropriation of the property not justified by military necessity. Plus that is applied the international human rights law. A variety of international human rights treaties apply to the proceedings. Among the most important of these are the International Covenant of Civil and Public Rights, International Covenant on Economic, Social and Cultural Rights, the International Convention on Elimination of All Forms of Racial and Discrimination, the International Convention of the Elimination of All Forms of Discrimination Against Women, CEDAW, the Convention on All Rights of the Child, and the Convention Against the Torture and other forms of cruel, human, degrading treatment and punishment. Both states, Palestine and the occupying force, are parties to these treaties. Established norms of general international law applicable to the proceedings. As stated by the International Law Commission, norms of general international law, jus cogens, embody three essential characters. One, they protect the value of fundamental to the international legal order shared by the international community as a whole. The second, they are universally applicable by virtue of their non-derogability, since states cannot derogate from them by creating their own special rules that conflict with them. They are superior on other norms of international law entailing obligation of an erga omnes character, the court itself has recognized the erga omnes character of such obligation. These are the norms. First, the inadmissibility of the territorial acquisition by threat or by use of the force. The prohibition against the threat or use of the force against the territorial integrity or political independence of another state is enshrined in the Article 2, Paragraph 4 of the United Nations Charter and is an essential cornerstone of the international legal order. The article, I quote, the Article 2.4 provides that all members shall refrain in their international relation from the threat or use of force against the international integrity or political independence of any state, or in any other manner in consist with the purpose of the United Nations. In case of the armed activity on the territory of the Congo, the court has stated that the prohibition of the use of force is a cornerstone of the United Nations Charter. Then we go to the second paragraph, which is the prohibition against racial discrimination and apartheid. The prohibition of racial discrimination and apartheid is reflected most in CERD, as the court has very recently underlined that that 182 states are parties in the CERD, a fact which confirms that universal character of the convention. Those parties include both of state of Palestine and the occupying force. It is well established that the prohibition of the racial discrimination forms part of customary law and has long been recognized as premonitory norm. The court in Barcelona Traction considered the prohibition of the racial discrimination to be a norm of erga omnes character, stating that such obligations derive from, example, contemporary international law from the outlawing of acts, aggression, and genocide, as also from the principle and rules of concerning the basic rights of the human person, including protection from slavery and racial discrimination. Third, the obligation to respect the right of the self-determination. The right of self-determination exists in customary international law and recognized by the United Nations Charter, as well as in the ICCPR and ICESCR. It must be also stated that the obligation to respect the people's right of self-determination is a premonitory principle of the general international law. As the court noted in the East Timor case, that right in self-determination is one of the essential principles of contemporary international law, enjoying an erga omnes character. The United Nations General Assembly has repeatedly confirmed the right of Palestinian people to self-determination. For example, the resolution 2672 of the 8th December 1970. It recognized that the people of Palestine are entitled to equal rights and to self-determination in accordance with the Charter of the United Nations, and that full respect for the inalienable rights of the people of Palestine is an indispensable element on the establishment of a just and lasting peace in the Middle East. Mr. President, members of the court, now we come to the illegality of the Israeli occupation of the Palestinian territory. The Israeli 6 decades occupation of Palestinian territory is a continuing gross and systematic breach of its legal obligation under the under the United Nations Charter and the general international law, also international humanitarian law, international human rights law, and customary international law, including the violation of at least 3 premonitory norms of general international law, of jus cogens and erga omnes charter. It shows that Israel has annexed and plans to continue to annex Jerusalem, Al-Quds, and the rest of the West Bank. That has composed systematic and comprehensive racial discrimination tantamount to apartheid against the Palestinian people, based on their race, and that it has denied their right to self-determination in their own land. In view of these policies and practices, Israel's occupation of the OPT is unlawful, rendering Israel's continued presence in the OPT and internationally wrongful act as seriously breaches the last 3 premonitory norms of the general international law. Derogation from which is not permitted. Israel's occupation of the Palestinian territory seriously breaches premonitory norms of the general international law, and the occupation of the OPT seriously breaches the at least 3 premonitory norms of general international law, derogation from which is not permitted. On the matter of self-determination, the occupying power has not only denied, Israel has not only denied the right of the Palestinian people to self-determination, but actively tried to suppress and to extinguish it even after the court's ruling in 2004. That Israel has under obligation, erga omnes, to respect the right of the Palestinian people to self-determination. Israel has, in fact, escalated the policies and practices with the specific intention of permanently precluding the exercise of the right of Palestinian people, including their right to independence and in their state. It is very apparent and evident that the General Assembly considered the Israeli military occupation as illegal, and Security Council the overriding necessity to the prolonged occupation when the occupation was in its early years. There is no doubt that it is unlawful, is even more apparent of the flagrant now that has come to the 6 decades. As consequences of Israeli prolonged 6-decade occupation of the OPT is a clear violation of premonitory norms of the general international law, derogation from which is not permitted. The occupation itself must be regarded as illegal with all relevant legal consequences that attach under the law and international responsibility. This means that it must brought to an immediate and unconditional end and total end. Mr. President, distinguished justice, what we mentioned is also means that the Palestinian people has the right to resist the occupation by all means, and it is a moral and legal obligation upon all states to assist and support the Palestinians in their legitimate struggle for liberty and independence. Now, Mr. President, members of the court, come to the consequences. We start by legal consequences on the occupying power. It must fulfill the occupying power, or Israel must fulfill its obligation to respect the Palestinian people's right to self-determination. Israel must immediately and the violation of the international obligation to respect the right of the Palestinian people to self-determination by ceasing all acts and measures that prevent and impede the Palestinian people from exercising their right to self-determination, including the immediate cessation of the occupation in all its manifestations. The obligation of the state responsible for an act contrary to the international law in general and international law. Accordingly, Israel is obligated to immediately cease of violation of the legal obligation in Jerusalem and the occupied Palestinian territories as a whole. The cessation of this violation includes, inter alia, the dismantling of the illegal structure, including the settlements and the wall. Israel shall be obligated to make restitution and compensation for the damage suffered by the Palestinian people, and Israel obligated to immediately repeal all these laws that aims to racial segregation and discrimination enshrining in the apartheid regime imposed against the Palestinian people. The other consequences, the legal consequences for the third parties or for the third states. Given the orga omnis nature of the right to self-determination in accordance with the standing resolution of the United Nations General Assembly, it is also incumbent on all states to ensure that any impediment to the exercise of the right of self-determination by the Palestinian people is brought to an immediate end. In view of the nature and importance of the rights and obligation involved, all states have an obligation not to recognize the illegal situation resulting from Israeli violation in the occupied Palestinian territories, including Jerusalem. They are also obliged not to provide aid or assistance in maintaining the situation created by these illegal acts. Furthermore, the states parties to the Fourth Geneva Convention are obliged to ensure that Israel complies with the international humanitarian law as enshrined in that convention, including the forcible transfer of Palestinians and the transfer of Israeli citizens in the occupied Palestinian territory. Also, there is a legal consequences on the UN and all the United Nations. The United Nations, and in particular General Assembly and the Security Council, should consider what further measures are necessary to remove without delay any obstacle of the realization of the Palestinian people's right to self-determination, and to take necessary measures to ensure the implementation of its relevant resolution without further delay. Then also the United Nations should consider that further action is required to bring illegal occupation, ensure the implementation of the relevant resolution without further delay. Mr. President, distinguished judges, lately we have the Libyan state submission. I will, with your permission, I will give the floor to my colleague, Dr. Nasser Al-Ghita.
I thank Professor Al-Gihani, and I'll give the floor to Mr. Nasser Al-Ghita. You have the floor, sir.
Mr. President, members of the court, it is my honor to appear before you today on behalf of the state of Libya. And with your permission, I will proceed to the final points of our presentation today, which is the submissions to the court. We submit to the court that the court has jurisdiction to deliver the advisory opinion requested by the General Assembly, as there are no grounds for declining to exercise its jurisdiction. We believe that Israel is responsible for serious breaches of obligations arising under peremptory norms of international law, including but not limited to the illegality of the admissibility of the acquisition of territories through the use of force, and the prohibition of aggression, the prohibition against racial discrimination and apartheid, and the right of the Palestinian people to self-determination. The occupying power is obliged to immediately, unconditionally, and completely end its occupation and withdraw from the OPT. This entails, inter alia, revoking all legislation and measures aimed at the annexation of Jerusalem and the rest of the OPT. End of aggression, and the blockade on Gaza, withdrawal of all occupation forces, and dismantling of its illegal settlements and their associated regimes. To revoke all of its discriminatory legislations, measures against the Palestinian people, and to respect the unalienable rights of Palestinian people to self-determination and the Palestinian refugees to return to their home. To provide assurance and guarantees of non-repetition of the above-mentioned violations. To make full reparation for injuries caused by the policies and practices vis-à-vis the state of Palestine and the people of Palestine, as a result of the internationally wrongful act or actions. All states and international organizations, including the United Nations, are obliged not to recognize the illegal situations resulting from the international wrongful act of the occupying power, not to contribute to the violations of the right of the Palestinian people, and by not rendering aid or assistance in any way to the occupying power, to cooperate to protect the right of Palestinian people and to end the occupying power's violations of those rights, by enabling the Palestinian people to exercise their right to self-determination, and by holding accountable those responsible for crimes related to the colonization of the West Bank, including East Jerusalem, the unlawful annexation of the OPT, and the blockade and the current aggression on Gaza. And more generally, the violations of the fundamental rights of the Palestinian people as a whole, including the right to self-determination and to be free from racial discrimination and apartheid, as well as the right of Palestinian people to life and liberty. I would like also to stress that our observation before the court today has no legal effect in relation to the recognition of Israel. Mr. President, members of the court, this brings our presentation today to the end, and I thank you and your member of the court for your kind attention. Thank you.
I thank the delegation of Libya for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.